Good afternoon, everyone. Sorry for the slight delay in starting the webinar for today. A very good afternoon to all present. I am Advocate Divyansh and Rathi, Managing Partner at Lexidem and Rathi Law Firm and founder latestlaws.com. I would like to welcome you all on behalf of Team Latest Laws, Indian Dispute Resolution Center and lecture series on law to today's Lexidem webinar on topic of law of sedition vis-a-vis Article 19 of Constitution of India. Today we are highly privileged to have with us our esteemed panelists for the discussion. First, we have with us Honorable Justice Iqbal Ansari, former Chief Justice Patna High Court and currently a Chairman, Human Rights Commission, Punjab. Lordship was elevated to the bench in Guwahati High Court as judge in 2002, where he was in charge for Northeast Judicial Officers Training Institute. He also served as Executive Chairman of State Legal Services Authority in Arunachal Pradesh and Nagaland. In 2013, upon his transfer from Guwahati High Court, Lordship joined Patna High Court as a judge and thereafter retired as Chief Justice of Patna High Court in 2016. After that, he has joined as currently as chairperson in Punjab as State Human Rights Commission in 2017. Welcome, Lordship. Next, we have with us Senior Advocate Rakesh Tiku. Rakesh Tiku, sir, is a Senior Advocate practicing in Delhi High Court and Supreme Court of India. He is also former Chairman of Bar Council of Delhi. Welcome, sir. We have with us Senior Advocate K.K. Manan, sir. Sir is a Senior Advocate in Delhi High Court and Supreme Court of India. He was also appointed as Chairman of Bar Council of Delhi in 2007 and held his office till 2008, and he was later appointed as Chairman again in year 2014. Welcome, sir. Next, we have with us Senior Advocate Geeta Luthra, ma'am. Geeta Luthra, ma'am, has been practicing in Supreme Court of India, Delhi High Court, and various other courts. She is also President of Indian Council of Arbitration, FICCI, member of ICC Chapter Core Committee, member Law Asian International Academy of Family Lawyers. Ma'am has been practicing in various fields like human rights, criminal law, and matrimonial law. She has also lectured at various universities, law schools in USA, UK, and other countries. Welcome, ma'am, to the webinar. Next, we have with us Anu Mehta, ma'am, partner at Arbiters and Sage. Anu Mehta, ma'am, has done her LLM in human rights labor law from prestigious ILI University. Ma'am is a dynamic young lawyer and has various reported judgments to her credit. She is also known face in public interest litigation, where she helped amend law for betterment of society. Welcome, ma'am. We are highly grateful to our panelists for sparing time out of their busy schedules and have joined us for this webinar. This webinar is also being telecasted live on our Facebook and YouTube channels. The viewers and attendees can send in their questions via the via the chat facility available on the screens and also on the Facebook chat facility. These questions will be taken at the end of the session. I would like to request our viewers to keep their mics on mute, and any queries which they have, they can ask only through the chat facility. Now I would like to ask Rubinder sir, who will be the anchor for today's moderator for today's webinar. He is a partner at Arbiters and Sage to take forward this session. Rubinder sir. I think so. Rubinder sir hasn't joined. Probably he will be joining in some time. I would now like to ask Justice Iqbal Ansari to share his thoughts on today's topic and start the webinar with his kind words. Lordship. Lordship is on. Let me unmute Lordship.
Can you hear me now?
Yes, Lordship.
My distinguished co-panelists and the learned participants. This topic reminds me of the famous quote of Thomas Jefferson, third President of the United States and principal author of US Declaration of Independence. His observation was that when the people fear government, it is tyranny. But when the government fears people, it is liberty. So from this point of view, if in countries like India or any other country, if the people fear government, there is tyranny. But if it is the government which fears the people, then it is liberty. Now, this law of sedition is something very important and unique in the sense that with the coming into force of the Constitution of India, the parameters of law have changed, because sedition was there before independence and it exists even today. Then what is the difference between the law which was there earlier and the law which as stands now? We all know that immediately preceding the Constitution of India, we were governed by Government of India Act 1935. I don't know how many of us are aware of the fact that under the Government of India Act, the oath was prescribed for the ministers, the Prime Minister, the Chief Minister, the Chief Justice, and the judges, similar as we have today in the Constitution. But interestingly, the oath required the subscriber to say that I owe allegiance and shall remain faithful to the King of England and Emperor of India. Mind you, and not only King of England and Emperor of India, but his heirs and successors. So every person who used to take oath, whether he's a chief minister or he's a premier of any of the states in India, or even if the chief justice or the judge, he was to take an oath declaring
Good evening,
his...
sir.
Good evening. Declaring his...
Good evening, sir.
Good evening. Declaring his loyalty to the King of England, who was described as the Emperor of India. And as I said, not only to him, but to his heirs and successors. So our law today, when we take oath, it is in the name of the Constitution of India, which means the Constitution which has been given to us by the people of India. So in the past, when we were governed by the Government of India Act, our loyalty was to the British government, but rather the King of England. Today, our loyalty is to the people of India. Now, Gandhi's trial brings out a very clear picture of this aspect of sedition. When Gandhi was tried, his reaction was that you can't insist me to have affection for the government. You see, the Gandhi trial was not a contested trial. When the charge was framed and it was read out to him, Gandhi reacted by saying that whatever facts have been stated in the charge, they are correct. But to my mind, I have not committed any offense. But if under the law that you are required to administer, if there is any offense, then in that event, you do your job and I have done my job. You can see the majesty of this English church. He says in the observation, while concluding his judgment and before pronouncing such sentence against Gandhi, that it is rare in the history of mankind that a person like you is tried in a court of law. And I also know that I will not be having another person of your stature who would be tried on charge of sedition in my court. But you must remember that law is not respecter of personalities. And then he pronounced Gandhi guilty and passes the sentence, but concludes by saying that if at any future time if the Crown, that is the King of England, is pleased to pardon you, nobody will be happier than me. Now, when the Gandhi says that you cannot insist on my being loyal, we must keep in mind that those days were the days when we were governed by the Britishers, and we were required to subscribe oath in the name of the King of England, declaring our loyalty not only to him, but his successors and heirs. And it was in this situation that Gandhi said that you can't insist on my having affection for the government. Now, with the time that has passed, we have now the state government and the central government. We must bear in mind that there is a difference between the state and the government. Everything which is said against the government does not become anti-national, because a state or nation stands on a far superior position than the government, because the government will keep changing, whereas the state or the nation will remain permanent. We must also keep in mind that government will include not only the ruling party, but also the opposition. So the question will be, which is the theme of our webinar, whether we have a right to have disagreement with the government. And if we have disagreement with the government, which has clearly come out with the Doa's case recently, will it amount to sedition? Because this is also something which one has to keep in mind, that the definition of sedition under the Indian Penal Code says that if anybody says or writes anything and thereby incites or bring into hatred, contempt, or disaffection towards the government, it is sedition. So that means anything that anyone writes, anyone speaks, which brings the government into contempt or creates a disaffection towards the government established by law, then in that event, he commits sedition. But in a democracy, as we know, democracy is that it is the government of the people, for the people, and by the people. But the essence of democracy is that we agree to disagree. That is the soul of democracy. So if we have a right to disagree, and that is why Article 19 guarantees a fundamental rights, will it mean that our criticism of the government will amount to sedition? And that is what we are required to discuss here. When will the criticism of the government will amount to sedition, and when will it be protected by the fundamental right of free speech and expression? Yes, Rubinder. Can you hear me?
Yes, sir. Yes, sir. You're audible, sir. Yes, sir.
So who is moderating? You are moderating, or he has appeared? That's why I'm asking.
Yes, sir. We are there, sir.
Achha, theek hai. So I continue?
Yes, sir. Yes, sir. Please.
Thank you. So what we find that in a democracy, dissent is possible, because that is the heartthrob or the very bedrock of democracy. Now coming the most important case which the Supreme Court has recently relied upon, as we all know, is Kedarnath Singh's case, delivered in 1962. Now, in this particular case, the Supreme Court, unfortunately, it has not been noticed that Supreme Court has read down the law. And what it has said is that if there is anyone who speaks or writes anything in some effect, it says that if it triggers violence or incites people to commit public disorder, then in that event it is sedition. Meaning thereby that if I say anything which creates public disorder, or if I say anything or I do anything or I incite people which triggers violence, then in that event it is sedition. So this definition does not really, or proposition does not really is what the statute 124A of Indian Penal Code says. So since the provisions of sedition have been read down, it means that we will go by the definition which the Supreme Court has given. So in order to be sedition, we will have to find out whether what has been spoken, what has been written is likely to cause violence or is likely to cause public disorder. If these two things are there, then it is sedition. If these two things are missing, then it will not be sedition. So if Vinod Dua's case, you will find by no means it can be said that he was instigating anyone to do indulge in violence or to go for a public disorder. So that kind of thing is not possible, and that is why the Supreme Court has struck down the case which has been brought against him. And now it is for all of us to decide, because there is a view that the law of sedition has to be done away with, consigned to the dustbin of history. The other view is that no, it should be written. The third view is that no, it should be written with appropriate modification. And in this situation, we have to now decide what we are going to do. But remember, please, that what we read in the newspapers and the articles about sedition is not really the law in India. The law in India is what Supreme Court has said in Kedarnath Singh's case. So if anybody's act is covered by Kedarnath Singh's case, he can be held guilty of sedition. Otherwise, he cannot be held guilty of sedition. Can I continue? I don't know.
Yes, sir. Yes, sir.
Can I continue?
Yes, sir. Yes, sir. Please.
Much. There is one thing which, there are two, three things which I have to also point out, that it was not that people unpatriotic had tried to bring in sedition as a law. If you recall, it was Sardar Patel who had mooted the idea in the Constituent Assembly of having sedition as a ground for imposing a reasonable restriction on the freedom of speech and expression, meaning thereby that freedom of speech and expression was made subject to the law of sedition. There was furor in the Constituent Assembly, and ultimately that amendment which he had proposed had to be withdrawn. So it is not that Sardar Patel was not a patriotic person. He was perhaps far more patriotic than many of us. And the person who really espoused the cause of people in India that we are not today hold very dear to our heart is K. Munshi, who had objected to the law of sedition being made as a ground for imposing on the right to freedom of speech and expression. There is one more thing. In Vinod's case recently, the Supreme Court has turned down the prayer for laying down the guide for the purpose of deciding whether a case falls within the parameters of sedition or not. But something which we must note is that this offense of sedition was earlier non-cognizable. It was subsequently made cognizable. Thereby, it is possible for the police not to arrest without warrant. Perhaps the law needs to be non-cognizable so that at least there is a chance of a kind of a judicial scrutiny or scrutiny before any FIR is registered against a person on the ground of or the allegation of sedition. Now we have one more thing which we have to bear in mind, that we find many times the courts going on emotion and causing perhaps harm to the institution of judiciary. Because there have been uproar in the past 6-7 years that the judiciary is calming down. But we can't forget the fact that there was a time during emergency when even the Supreme Court had cowed down and held that a person will not have freedom of fundamental rights because his rights will stand suspended. And therefore, many people remain under preventive detention because of the fact that the Supreme Court refused to interfere. Now, I have one aspect to point out, that if our audience will recall, that Kanhaiya Kumar, who was leading the student union, he is alleged to have raised some slogans. Whether he had raised the slogan, he had not raised the slogan, it is only the trial that will determine. But for my purpose, what I am trying to point out is that the judge, while refusing bail, had said that people like Kanhaiya Kumar are gangrene to the society, and we applauded. The question is that rejection of bail means that a person will be convicted. The answer is no. A rejection of bail does not necessarily mean that a person will be convicted. So if tomorrow Kanhaiya Kumar is acquitted, what will happen to the observations such as that he is a gangrene? So a lot of judicial restraint is required to be applied when we make an order on the judicial side. And now it is for people to decide whether they will have a law which will prevent anyone's inciting violence or causing public disorder. Because if we take the view that notwithstanding the fact that there is a provision, and in view of that provision, any kind of incitement to public disorder or violence is sedition. And we will have to also keep in mind, as I have said, that it is the proposition of law prescribed by the Supreme Court in Kedarnath Singh's case, which should be taken as the definition of sedition for the purpose of registering a case against any individual or association of persons. Thank you.
Rubinder sir, please unmute yourself.
Thank you so much, Justice Ansari, sir. My apologies for coming late. There was a connectivity issue, I guess. So thank you for such an insightful opening statement. May I now request Senior Advocate Rakesh Tiku sir to please kindly throw the opening statement on the said topic. Tiku sir.
Thank you. Good evening, everybody. Thanks, Justice Ansari, for giving this background which many of us would not be aware, because sedition as a law is something which we have inherited from the Britishers. Gone are the days when Lokmanya Tilak trial versus Vinod Dua. A different situation, different political coloring. So, and Lordship knows that even in earlier days, there was a difference in the judgment of the Federal Court and the Privy Council. Ultimately, that all led to even one of the judges in Supreme Court disagreeing and saying the word, unless and until word public order is there, I cannot uphold any law which can decide the legitimacy. So therefore, that 1951, they had the First Amendment incorporating, giving power. But what really worries me, I was reading it that as on date, in spite of the journey of Kedarnath, starting 62 till 2021 in Vinod Dua's case, we have 57 FIR registered against the journalists. Now, let us be clear about it. When we say sedition as a law tests on the touchstone of my right of freedom of expression, one would ideally think, and all may agree, that we got to have a balanced approach. Just because a law or a statute is capable of being misused by the executive, for which there are legitimate legal remedies, that may not justify to hold the view that since the law as it exists has been mutilated, has been misused by the executive, it should be struck down. The Kedarnath 62 onwards, if Lordship remembers, Kedarnath, they although dismissed the appeals arising from the High Court, out of 3, 2 appeals were dismissed, 3rd was upheld, but they laid down the principle that what would be exactly the ambit of 124A. Lordship rightly said, government versus the state. One may use not the expression government, one the people who manage the government versus the state. May be a right expression. Because I could be critical of the measure adopted people at the helm of the affair, as it could be negative criticism, it could be healthy criticism, but nevertheless, when our constitution says that we have a democratic country, which I am told means democracy is tolerance of dissent. And as Justice Ansari rightly quoted Jefferson, that the government must be alive to the criticism. But let us look at the ground reality. Today, in last nearly 50 years from Kedarnath, have we improved or have we gone back? Today in the morning I read newspaper, FIR filed against a known actress, a writer, against the writing which he made about Mr. Patel, who is the administrator of Lakshadweep, who he called today as a bioweapon. The gentleman, the person, the actress was merely saying that the measure adopted by this Patel as an administrator is going to have an ecological disaster for that island. So therefore, he is termed, in her opinion, as a biological weapon. FIR registered. Now, Mr. Manan, who is also there, he will also agree he has a vast experience. The idealism, notwithstanding guidelines, principles laid down in Kedarnath way back in 62, have they been followed? At the drop of the hat, you have an FIR. Now, today, let us not compare our judicial system with the Western European countries module. Here, a registration of FIR is a slur on a person in a society, in an institution where she may be working. And this, notwithstanding Lalita Kumari arrest, be it Arnaz Goswami, who is sought to be arrested by the Maharashtra government, or be it, or vice versa, Vinod Dua is sought to be arrested by the Himachal Pradesh government. It is irrespective of the political contours. So therefore, one has to think it, while we all appreciate that the Act section has to be there, but if Lordship recalls, in the Vinod Dua, the second prayer which was made on the line of Jacob Matthews case, that like in a doctor's, why do not we also have some mechanism whereby which there is some kind of a adjudicatory, if not legal, adjudicatory reappreciation before the system rushes for a FIR. This Supreme Court turned down. In fact, Justice Ansari rightly said, if that be so, fine, then make it non-cognizable. At least that will give a time. Now today, my lord, let us not forget, media, social platform, there's so many venues. When you say whosoever incites or shows disaffection, writing words, you have YouTube, you have WhatsApp, you have dramas, you have movies, you have a demonstration outside someone's house, you have Kisan movement, you have CWA, or you also have some journalists criticizing the defense deal with the government of India or some corruption matter. If it becomes an unruly horse, it is disaster. Because the dissent is something which is a foundation of a democratic institution. Well, all that one has to keep in mind, where do you draw the Lakshman Rekha? Your criticism about methodologies, measures being taken by the government may not be acceptable to the government, but that by itself would not be sedition. But if you cross the Lakshman Rekha, that your contents are added with, in a Punjabi, what you call a tadka, which will give an incitement to the public, come for outrage, come to the street, discipline the government established by law. That is something which has to be guarded. But sir, I feel sorry, because let us not forget, Himachal Pradesh, like Vinod Dua, one gentleman says, I saw the program, Vinod Dua said ABCD. In my opinion, in my perception, this amounts to 124A. And you have some joker sitting there, some ASI, he says, Bayan sun liya, theek hai, case banta hai. Now, so where do we draw the line? I think maybe some way or the other, either the government by its own mechanism or by court's intervention, a situation will have to be risen that we'll have to try Jacob Matthews experiment here, because it is not only journalists. Let us say we the lawyers, we as a representative association, there is something which concerns the legal institution. Mr. Manan has been the chairman of the Bar Council for a number of times. He has serious issues. He may have a concern with lawyers. He wants to speak something. What comes the threat? 124A. So therefore, question is, a stage has come where one has to think either by social platform, by the thinkers or the government, where, I mean, Vinod Dua's case is more opinion, it's like an Operation Success patient death situation. It was not only Vinod Dua is being arrested or not, he was appearing through the investigation, through the your video recording. That doesn't give the solution. The last penultimate paragraph of the judgment, I read it carefully, they just kept silent. They say, we have gone through, we have gone through. So question is, in the rules have to be seen, their legitimacy to be seen, not only the academic way they are written, but the environment, atmosphere, ground realities, capabilities. Now today with the ruling party there being there and other states, there is the different political system is there, different political party there, A versus B, starts a war. You against me, I registered against. This is what we saw, one in Bihar, FIR, one in Maharashtra. So therefore, when we talk of sedition, there will have to have a system. All of us will have to someday or the other organize something whereby there is some pre-check. That's all I'll leave it at that. I can't hear you, Ansari. You're muted.
I just wanted to know in specific terms that according to you, the law of sedition with whatever way we guard needs to be remain in there.
But with a check by institutional, because your lordship, the courts have shied away. They have not shown that guts which should have been shown in a given case. Like in a doctor's case, see, sedition, what happens the moment case is registered, even let us accept it. Mr. Manan practices so much on the criminal side. Judge will simply say, oh, against the nation. See, the 124 is chapter 6, offenses against the state. The moment what state comes, a small joker sitting in the police station makes a complaint and the complainant believes. What will, when Manan starts arguing, no, Mr. Manan, see, this is a serious matter against the state. Mr. Manan says, sir, what has he said? He has said, sir, please improve your working. So therefore, but if you remove 124 totally, then I think there could be absence of legislation might create a problem. Though we have in some cases Office Secrets Acts, MDMA, the disaster management is all against a limited period. But an absence of act, something has withstood the test. See, let's not forget 1860 IPC made. There was no 124A. It was inserted in 87. 10 years. It continued. The change became from British India to India. The government of India also realized. And let us see, there are three explanations. Unlike the one explanation which was under 124A original, which Britishers made. The first is more of elaborative, explaining what is the concept of your disaffection. But explanation 2 and 3 puts a break, gives a lever, gives an exit window. But question is, a tool in the hand of an unexperienced person can be dangerous. So there the government has to be like we have in cases of NDPS, which say there should be minimum person of at this rank, or in some cases minimum, some high level, either the government makes rules that high level DCP person should examine himself, record the reason for, not because I say that in my opinion it is seditious. Something will have to be where the Supreme Court fell short of it, in my opinion, regretfully.
Thank you, Tiku sir. It was really insightful opening given by you.
Thank you.
May I switch over to Geeta ma'am? Ma'am, originally section 113 of IPC of 1837, then ma'am 1839 proposed proposed that the sedition law be incorporated, but it was not, ma'am. It was omitted till 1860, and Tiku sir has rightly said so, ma'am. Ma'am, would I, in brief, ma'am, because we will have a question answers round also, request you, ma'am, to give an opening statement of yours, ma'am, regarding this law, ma'am. Geeta, ma'am. So very well, I switch over my question to KK Manan, sir. Sir, I repeat my question once again, sir. Is KK Manan, sir, am I audible to you, sir?
Oh, yes, yes, you are audible.
Thank you, sir. So originally in section 113 of IPC of 1837 and then 1839, the sedition, sir, was omitted. Sir, as Tiku sir has rightly said, and as Chief Justice Honorable Justice Ansari sir has said, this is the old draconian law, sir. Victims of which consisted of Mahatma Gandhi, Bal Gangadhar Tilak. Sir, if I rightly correct and if I've rightly read what sedition law is, basically, sir, the purpose of this act was, sir, to suppress the freedom of speech in colonial time in 19th century qua Indians, sir. So this act was basically used against a journalist, sir. If I rightly recollect, sir, Mahatma Gandhi had in fact written his biography sitting in the jail, sir, because of this act. Similarly, sir, Nehru was also twice sent behind bars.
Sir, despite all this, today, almost 70 years passed by, we yet have this act. So would I request you to please kindly throw some light on this enactment of this act and what relevance does it have as of today? And since you, sir, being a trial court leading lawyer, so what experiences have you faced? In brief, sir, can I request you so that after that we'll come in question answers round 2, sir?
May I start?
So,
Justice Iqbal Ansari ji, Rakesh, Tiku, my brother, Luthra ji, Mehta ji, Robbie ji, and rising star in the bar, Divyansh, Rathi. Before answering your question, I would like to pay my tribute to the departed schools of lawyers, judges who passed away in this pandemic period. More than 500 lawyers and many judges, high court judges, retired judges, sitting even additional session judges have been passed away because we are assembling after many months. It is my prime duty to pay tribute to the departed souls and pray that their souls rest in peace. You see, Mr. Ansari and Mr. Tiku has elaborated the law of sedition. Meaning of a sedition is refer to overt action, gestures, or speech by a person in oral or written form expressing his or her discontent against the government in the state, aiming to incite violence or hatred against it. Section 124A of Chapter 6, that whoever by spoken words or written words, signs, etc., excites or attempts to excite or hatred or disaffection towards the government of India is said to have committed the crime of sedition. In fact, the topic which was also including, that is Article 19(1)(a), guarantees freedom of speech and expression. Question arises that whether right is absolute right or not. This right has limitation. This right is subjected to reasonable restrictions as imposed by law on the grounds security of a state, friendly relation with foreign states, public order, decency or morality, contempt of court, defamation, incitement of an offense, sovereignty and integrity of India. This means any speech should not be in contrary to any of these grounds as mentioned, as I said there earlier. In fact, Mr. Robbie and my learned colleagues must be known. What is the history of this sedition? This section, in fact, initially had its base in the IPC, that is Indian Penal, that there the code, as Section 113, when Lord Macaulay drafted Penal Code in 1837. For some reasons, it was omitted and finally added in 1870 on the suggestion of James Stephen. Stephen's version of 1870 was amended to a large extent throughout IPC Amendment Act 1898. The current version stands similar to this 1898 section, having minor alteration. This was done as a response to the rising radical Bhavi's movement led by Sayyid Barlawi. Moreover, people were increasingly demanding more autonomy and independence for India. This was against interest of the British government. Therefore, it sought to curb people's speech and expression through this law. Sedition was made cognoscible, as my learned panelist Justice Ansari ji has said, for the first time during the tenure of Mrs. Indira Gandhi via the 1973 CRPC amendment, or it was in fact replaced by 1898 CRPC. Before taking, you see that there is another judgment, a very important and famous historical case before Kedarnath 1962, that was Mahendra Dutt Majumdar versus King Emperor 1942, in which Majumdar was sentenced for 6 months along with a fine of rupees 500. But the Privy Council at that time judgment delivered that the court, in fact, that court had held that the sedition essentially means a person's intention to promote public disorder or his reasonable anticipation that his words or action will promote public disorder. Therefore, the incitement to violence or the tendency or the intention to create public disorder is a crucial element of sedition. Regarding the fact of the case, it was held that the speech by Mr. Majumdar did not exceed the legal limits of criticism of the government and therefore could not be considered sedition. At that time, it was under Defense of India Act 1939. Now that was replaced by 1947, in fact. Even there are other judgments, my lord, you know better than me, that the judgment of Ram Nandan was a state in 1958, heard by Allahabad High Court. There are Punjab and Haryana High Court also struck down the law. Then the Honorable Supreme Court delivered a judgment in 1968, brought back sedition to the Constitution, interpreting the section to say it only applies if there is incitement to the violence. Now, the question is that not only this section, I may remind you people that section 107, 151 CRPC also being invoked against the freedom fighters by the British government. Mahatma Gandhi, time and again, Pandit Jawaharlal Nehru, Lala Lajpat Rai, and Sardar Udham Singh. First, he was charged before 302 IPC for sedition also. And lot of, even I can name lot of freedom fighters, because 1,000 people have lost their lives and life. Even you have, you know it, that in Ram Nandan's case in 1959 also, and the judgment under for the seditions, section 124A, which was again, it was elaborated in Bihar also, but I will not take much time, but only I will say, because the latest in the trial court, Kanhaiya Lal and this Kanhaiya Kumar, and he was released on bail by Justice Pratibha Rani by Delhi High Court, using the same judgment, Kedarnath Singh, 1962, and she has referred number of other judgments of the Honorable Supreme Court and Delhi High Court. And in fact, arguments in favor of section 124A is usually it preserves national integrity, punishment for hostile activities, contempt, but against is vague law, inconsistent with international commitments, unnecessary provisions. But at the same time, I will again remind that you remember that there was another case of Balwant Singh versus state of Punjab. And there was number of other cases. You remember that the Supreme Court overturned the conviction for sedition and promoting enmity between different groups on the ground of religion, race, etc. 153A IPC, and acquitted persons who had shouted. Now I am using, and I remember that, Khalistan Jindabad, Raj Karega Khalsa, Hindu nu Punjab तो कट के छटांगे, हुन मौका आ गया है. These were the words Ultimately, late evening 31st October 1984, that was the few hours after Indira Gandhi's assassination, outside a cinema hall in a market frequented by Hindus and Sikhs in Chandigarh also. So, words and speech can be criminalized and punished only in a situation where it is being used to incite mobs or crowds to violent action. Mere words and phrases by themselves, no matter how distasteful, do not amount to a criminal offense unless this condition is met. Now, as my learned friend Mr. Tiku was referring ASI or such and such, no ASI Tikuji is interested to invoke these sections until orders from the high-ups are there. High-ups means, like in Delhi, Commissioner of Police will be directed by the government, Home Minister, Home Secretary, etc. So it is not a new thing, whether it is today's government of BJP or there was a Congress also, even third forces government also. This section seditions and 107151 CRPC usually be invoked against the leaders and against the persons very easily. But unfortunately, they forget it that courts are there to scrutinize. Ultimately, police can execute, can book a person for the sections, but ultimately scrutiny will be done by the courts. And court time and again, as my learned panelist, Justice Iqbal, he having vast experience, must be a lawyer also before elevation, and having experience on the bench also, that sometime in criminal cases, false cases are being instituted by the investigating agencies. And 99% cases are not false in criminal cases. We criminal lawyers know it. But it is our duty to defend them this way or that way. But sedition is the section. Now this government, though I don't belong to any party, having friends in every party, but unfortunately, young two girls, one brought from Bangalore, she was not released by a metropolitan magistrate, did not apply his judicial mind. Ultimately, the learned additional session judge passed a beautiful judgment, given the reference of Justice Pratibha Rani in Kanhaiya Kumar, giving the judgment reference of judgment Kedarnath and number of other judgments, and he elaborated each and everything and granted bail. Thereafter, anticipatory bails were also granted to those young, I will say children, because nobody was above 22 years in those cases. But my humble submission through this webinar to the government, whether the state government or the central government, please, for God's sake, don't misuse the law. Today, this law is used by you. Tomorrow, it will be used against you by the other government, because governments comes, governments goes. But unfortunately, these people forget always that the time will also come of a other person. But nobody can comment upon their conduct because they are at the helm of affairs. So they are the, I will not use the words, but unfortunate for the nation, for the society, for the country, but that this section is being misused, which should not be. Thank you very much.
Thank you, sir. Rubinder sir, you are muted.
Thank you so much, Manan sir. It's been a quite insightful opening from your end, and as expected from a lawyer, none that of Asaram and the former Prime Minister of India, Devi Gowda Sahab, and rightly, sir, you stated it. Now, before we move to question answers round, is Geeta ma'am audible? Ma'am, are you audible with us, ma'am?
Yes, very much.
Very good evening to you, ma'am. I hope you're enjoying Masuri.
Nice. Thank you so much. It's good.
Anytime. Welcome, ma'am. Ma'am, my question to you.
Behind her.
Oh. So, ma'am is enjoying.
So you're always welcome, Manan sahab.
Geeta ji, you're enjoying the weather there. At least last night you sent the rains, but again, please make it continue.
Sir, that was scrutinized by me. Anyway, sir. Geeta ma'am, coming on to the question, ma'am, I think 3 opening statements have been made, ma'am. Let's come to, let's get the format into a more serious one, ma'am. Ma'am, one of the characteristics of sedition is that it is inherently political, ma'am. Ma'am, around 800 cases of sedition were filed against more than 10,000 people in last 10 years, ma'am. Ma'am, what is your take on this?
So the take on this is that we've got this law from the British, and in Britain, it's been abolished. And they said that they had not, Lord Denning said that it's been obsolete for 150 years.
Yes.
So if it can be obsolete in that country for 150 years, I don't know why our pages of the penal code turned to 124A. I do not understand why they turned to 124A, and then most of those cases get dismissed. But while they get dismissed, they have already served their purpose. So they create a chilling effect, and that chilling effect is what is, as in fact, the quotation that was given by Justice Ansari, that if governments silence people, then it becomes tyranny in terms of Jefferson. And I can only echo what was said by Justice Ansari when he made his opening statement.
Right, ma'am. Ma'am, in fact, I believe that in London, there is a place, ma'am, where a person can stand and speak whatever they feel like and vent out what is in their heart without any fear of sedition or something, ma'am. I forgot the name of the park.
Well, they do it in Hyde Park Corner. So everybody sits with their little stools and they say what they like. But the more important thing is that we should be able to stand where we like and be where we like, whether on media or social media, and say what we like, not just in a corner. So I would be happy if we can say what we like, and ultimately difference of opinion just strengthens people. In fact, in this context, I'd like to quote my favorite quote from John Stuart Mill. And I don't know how many people are fond of his thought, but he said that truth is like a prism and it has many facets. And the one facet which is differing from the 99 may be actually the truth. And therefore, truth becomes stronger with its interaction with different viewpoints. He had put it far more eloquently than I have put it. But the fact is that the philosophy, underlying philosophy, is important, that we have to hear every opinion, and we can only become stronger with difference of opinion and become richer with knowledge of different viewpoints. So with that, of course, unfortunately, sedition is being used for political reasons, as is a question, across board, across parties, across different governments that have been in power, and for the most ridiculous reasons You do it against a cartoonist. You use it against a journalist who has received Padma Awards. What more can you say if, as Justice Ansari quoted Vinod Dua's judgment, I think by Justice Lalit, if I remember correctly. I can only say that the fact is it's used across board by every new government that comes to power. And the country from where we inherited it had by mistake missed it out on its statute book for India when Macaulay made 1860 the penal code. But it came back to haunt us later, and we can only be the sorrier for it.
Ma'am, point well taken, ma'am. Just adding on to what you said, ma'am. Sorry for this.
No.
I think, ma'am, originally when this was an offence till it was repealed in London, ma'am, or in Britain, ma'am, that time, I think the punishment also wasn't as much as given right now in 124A. It was, I think, 2 or 3 months, ma'am.
No,
Here it's 3 years.
I don't recall that. You see,
I think
ultimately it's a variable punishment. But the fact is that it's not, see, it will never go its full way because it will die. It will
ma'am,
die.
that's one of the questions I'll be asking you. That's one of the
Yeah.
questions I'll be asking you later, ma'am. Ma'am, point well taken, ma'am. Thank you so much, ma'am. Coming on to a surprise element, a surprise speaker, Mr. Pawan Naran. Bhaiya, are you there, sir?
Yeah, I am there.
Right. My question to you, since you have been writing so many blogs and which have been reported in the newspapers as well as in bar and bench and all, I took the leeway of inviting you, and thank you so much for joining us. May I request you and in fact ask you a question? Whether judgment in Shreya Singhal has been able to clarify the drawing of line which was left hazy in Nazir Khan, or that thin line where the legitimate political criticism of government ends and this affection begins. I'm using the word disaffection because it has got, even I think Mahatma Gandhi had clarified this during a trial which he stood. Ends and disaffection begins. Still cannot be certain. Would you throw some light on this, Bhaiya?
Yeah, thank you, Robbie. But before I come on to your question, I just want to say a few words. You know, we have been saying that this Sedition Act, this is a colonial legacy which has come to us. We forget that the entire IPC is a colonial legacy. We are continuing with it.
Correct.
And the unfortunate part is that when Article 13, which now is 19 in draft constitution, sedition word was added by the select committee, which was rejected, as Justice Ansari was saying, was rejected by the Constituent Assembly. And when the constitution was adopted, sedition was not there. But the misfortune of our country is, if we see the oldest democracy and the largest democracy, the first amendment by US was providing freedom of speech. And first amendment done by India in 1951. And that too by the same Constituent Assembly, which was that time working as parliament because the first elections happened in 1952, brought in amendment in Article 19.2 with addition of public order. And the reason was couple of judgments of Supreme Court and one judgment of Punjab and Haryana High Court, wherein they held that Section 124A, Madras Public Control Order and other aspects, since they were not part of 19.2, the sedition word was out, or other aspects were not covered. So under freedom of speech, the action taken against the persons, the proceedings were quashed. And that was the reason given by the then government to say that since these three judgments have come in, so we have to bring in this amendment. And please realize this amendment which came on for this first amendment, which was adopted in 1951, came into statute or constitution from the day constitution was adopted. So thereby covering the judgments which had been delivered by Honorable Supreme Court and Honorable High Court, saying that freedom of speech, under freedom of speech, sedition is not covered. Thereby, it is we ourselves, in one of my article I have mentioned, it is we ourselves have brought it back on us. Why do every time we say that we are continuing with the colonial legacy? Now, okay, in 1951, this judgment, this amendment came in. Then in 1962, the Kedarnath judgment came, wherein my Justice Ansari has also talked about it. My learned senior advocates friends, they have also talked about it. After Kedarnath, what we are missing is there was a judgment by Honorable Supreme Court in Ram Manohar Lohiya's matter in 1966.
Correct.
There, for the first time, they created boundaries of public order, because public order was added in 1902. Yeah, it is just 4 lines which I'll just read. It says, one has to imagine 3 concentric circles. Law and order represents the largest circle, within which is the next circle representing public order, and the smallest circle represents the security of the state. It is then easy to see that an act may affect law and order, but not public order, just as an act may affect public order, but not security of the state. So by this small paragraph in Ram Manohar Lohiya, it clearly crystallized as to what public order was, what was covered under 124A and other sections. However, subsequently other judgments also came in, as you said, in Nazir Khan, yes, there was a line which said that it is slightly blurred line is there. But Justice Nariman in Shreya Singhal has crystallized as to what is the impact or what is the essence of 124A and where it can be invoked or it should not be. I'll just read, there are 4 lines. There are 3 concepts which are fundamental in understanding the reach of this most basic human rights. The first is discussion, the second is advocacy, and third is incitement. Mere discussion or even advocacy of a particular cause, howsoever unpopular, is at the heart of Article 19(1)A. It is only when discussion or advocacy reaches the level of incitement that Article 19(2) kicks in. So if we keep in mind these 2 judgments, Ram Manohar Lohiya and Shreya Singhal, they clearly define the scope of invocation of 124A. Howsoever other judgments are coming, people have been, what Manan also said, Mr. Tiku also said, that somebody writing an article or somebody saying something in a state, a police guy will invoke 124A and register a case. Yes, amendments are needed. And accordingly, after these judgments came in, Law Commission in 2018 has come up with a consultation paper. It is a very detailed document which they have circulated for public opinion. There they have given 10 different issues which need views of the people as to how Section 124A, or what we say as sedition, can be deleted from the statute or can be, what you say, controlled by bringing in some other checks and balances. So it is a process which has to be undertaken by public at large, and especially we as lawyers have to be proactive. This consultation paper has come in 2018. I don't know how many people may have seen it, read it, or even given their comments on it. I'll take my case also. I've seen it recently, so I have not done anything on this. Yes.
Thank you so much, Pawan sir. It's been a good opening statement. I'll be coming back to you later. Anu, am I audible to you? Hello, Anu.
Please unmute yourself, ma'am.
Yes.
Anu, am I audible?
Am I audible?
Yes.
Yeah, absolutely.
Okay.
Right.
So,
a straight question to you.
Good evening, everybody. Yes, sorry.
Hi, welcome to
Please.
the show. A straight pinpoint question to you. You coming from a service background, coming from the chambers of Geeta Anand and Geeta Luthra ma'am and Pinky Anand ma'am, being a champion of human rights commission, having done courses on that. I ask you, I put it to you. Could you does the present sedition law balance itself with Article 19(2)?
Yes. Good evening, everybody. Good evening, distinguished panelists. So I think most of the entire topic has been completely covered. There's hardly any scope for me to answer that. But as far as my take on the law of sedition is, I feel that it is a very important and integral part of our law, because it relates to the national security, and it is the very pulse of securing the country from the anti-national elements. So as far as the validity of the law vis-a-vis the section 19 is concerned, we are talking about two contraries which are equally essentially important. It is pitching the interest of an individual versus the interest of the state. So there is no comparing the two. It is equally important, and within the reasonable restrictions, there has to be section article 19, that is the freedom of speech, has to be seen, that as long as it is not compromising the national interest or creating any public anarchy or disorder or disharmony in the state. So as far as that is concerned, so there has to be a balance in such a manner that the interest of the state is supreme vis-a-vis that of the interest of the freedom of speech of the citizens. So that has to be balanced in such a way within the reasonable restrictions.
Correct. Thank you so much, Anu. Sir, coming on to a technical question, can I ask the king of the trial court, Mr. K.K. Manan? Sir, may I draw your attention, please, sir? Sir, if I may read if I have the IPC in front of me, sir. Though, sir, I'll take a leave of reading out the essential part. Sedition 124A. Whosoever by words either spoken or written or by signs or by visible representation or otherwise brings an attempt to bring into hatred or contempt or excites or attempts to excite dissatisfaction towards the government established by law. So the word is the government, sir. It is not nation, sir. Sir, I think your smile is understanding. You're understanding the question that's being put across, and you're already having an answer for it. Sir, what kind of a language is it, sir?
No, you want me to define?
Absolutely, sir. I would.
Difference between the government and the nation.
Dissent.
Central government is always of the nation's government.
Sir, there is a difference, sir. I beg to pardon, sir. There's a bit of a difference, sir, in my interpretation, sir, which I may have, sir. Sir, three organs.
Section, let me clarify it. I know what you want. In fact, section 124A of chapter 6, it's crystal clear that it covered the state governments as well as the central governments. Central government as well as the state governments. It is not only for the central government or only for the state government. As I read at that time, you remember that among these articles, you see that in the Constitution, our Constitution has provided various rights mentioned under Article 19 to 22 to the citizens of this country. Among these articles, Article 19(1)(a) guarantees freedom of speech and expression. Question arises that whether right is absolute right or not. This right has a limitation. This right is subjected to reasonable restriction as imposed by law on the grounds like that security of the state, friendly relation with foreign states, public order, decency or morality, contempt of court, defamation, incitement of an offense, sovereignty and integrity of India. Word is integrity of India. Here is the answer.
Got it, sir.
Observe,
got the point, sir. Sir, I got the point, sir. Sir, I move further, sir. 124A, sir.
Yes.
Sir, I have read out the relevant parts, sir. Sir, in a democracy, we the people / citizens are
By the
sovereign
people,
now.
for the people.
Sir, we are sovereign right now, sir. We no longer are ruled by queen or the king or a dictatorship. So we have a single right to criticize the government which is working on our behalf. And if we feel that it has failed us, we have a right to ask question and hold it accountable for its action. Do we citizens not have a right to audit and question the policies freely, sir?
As I said, even the latest judgment in Vinod Dua also, if you go through the judgment, earlier this section was not cognizable, but I told you that in 1973, it was replaced the CRPC 1898 while during the tenure of Shrimati Indira Gandhi. Earlier, it was not even cognizable offense. Question is the nation. Nation means the India, sovereignty of India. And it is not the pure right खड़े होकर किसी को भी गालियां दो. गालियों का भी तरीका है. हर चीज को मतलब एक लक्ष्मण रेखा. I will say there is a Lakshman Rekha. You will find in criminal law, in IPC, there are 511 sections. Very right. There are other acts in criminal law, but you will find it benefit of doubt in criminal law. Likewise, in sedition case also, there is a limitation of right of our right is not unlimited. Presume it for a moment for the sake of arguments. May I abuse you in front of your family members in a filthy language, and which is, I'm using the word filthy language, not unparliamentary language. Is it my right given in the Constitution under Article 19? No. So there is a limitation, there is a Lakshman Rekha.
Right, sir. Pawan, sir, what do you have to say on this, sir?
Robbie, I'll just come and I'll support what that. You know, there is a difference between criticizing an individual, criticizing the government, and criticizing the country.
Absolutely.
These things are at three different levels. 124A only covers up the government of India. So thereby meaning it is not an individual. You may criticize an individual. He may position. But that will not come within the definition of 124A. How criticism is going to an extent where the government is being challenged, then that distinction comes in. So therefore, you see, Shreya Singhal is very clear on that. It says incitement. And as far as what you were saying about India is concerned, and what you were trying to ask Mr. Manan and trying to corner him, which you couldn't, just on a lighter note. On a lighter note.
I would love to lose because that's my victory in front of a senior like Manan, sir.
Nobody can corner.
Absolutely. He's a king of a trial court after all.
That's right. So therefore, I'm saying there's something else also. If you read the definition of unlawful activity under UAPA, which is section 2O. There you will find India is covered, a country is covered. So there are different other sections available under different statutes.
Interjecting for a moment, coming on to that, because I knew where you were going to come to. Since it's a very good, the debate has just taken fire right now. Do we require so many laws, 121, 122, 123, and then coming to 124, and then UAPA? Do we require so much laws, sir?
Can I say something?
Makoka is there. Earlier, Tada was there.
So I'll come on to
time
that.
to time, the law is being amended.
Tada has been repealed. Photo came in.
Very right. Time to
thereafter
time.
now, sir, this has come in, sir.
Ravi,
so my question is, do we require so many laws for booking a person? And sir, I move a step further. What is the result of conviction of these people booked? Conviction rates, Manan sir?
Very low. But exact
is it not a use of excess of law then, sir?
But very low. Here, this topic is a very, very vast topic. First, I always say, corrupt investigating agencies.
Correct. Now,
incompetent prosecution, and we are also contributing something.
I agree. I agree. Couldn't have placed it better, sir.
Can I add to this? Can I also add to this, Robbie?
Yeah, sure.
Am I audible? Yes. So I had to, in this reference to this, I have to say that there is a floating geopolitical scenario, and with the kind of relations we have with our enemy nations, and with the kind of warfare, it's not a traditional warfare anymore. So with the technological advancement and so many the explosion of the mode of communications, we need something like this provision to be able to check and screen enemy elements sitting in various parts of the world, and using these channels, and maybe finding sympathizers in our colleges and our institutes. Jamia Millia Islamia was a recent example of that. So there were fundings going on and all those kind of things. So sedition, of course, amounts to incitement, and all that needs to be checked. So I think this investigation under this particular provision would be very helpful to combat this kind of proxy war that is, prevalent in today's day and age.
Well said, Anu. Thank you so much. And sir, my question to Justice Ansari, sir.
Robbie, before that, just 1 second. What Anu says, I'll just come on to say on 1 minute. We have to see what Anu says. I agree. Geopolitical situation. We can't compare our laws with other countries who may be having different set of laws. There are 4 or 5 different nations which are our immediate neighbors. We have to take care of those aspects. Mr. Tiku is there, Mr. Manan is there. They are from 2 states which have suffered a lot. Whether now those laws are required or not is a separate debate. But what has happened is, by passage of time, UAPA being a 1967 act, when Tada came in, Tada was repealed, its sections were brought in UAPA. POTA came in, POTA was repealed, the draconian sections of POTA were brought in UAPA. So now what has happened is everything is there in UAPA. It has become a more important what you call a vibrant debate or justified debate. There may be different reasons. For that, you may be requiring 1 or 2 more webinars because you can't finish off these things.
Correct.
In this one.
So coming on to Justice Ansari, sir. Sir, what should be the judicial restraint while applying the law of sedition, sir? If I could have this question voluntarily answered. Sir, am I audible, sir?
Can you hear me?
Yeah, absolutely, sir.
So before I answer your question, let me just clarify one thing. Article 1 of the Constitution defines what India is. So we don't need another definition.
Correct.
If I have to throw away state governments, the UP, Bihar, Punjab, Haryana, anything, by violence, in the present scenario, will the law of sedition not apply? Because it is not India. India is a union of states. So nation does not mean India alone. Every state is a nation. Not that we have a couple of nations. India is union of states, and every state combined together has a nation. So any injury to any state will be regarded as an injury to the nation. Otherwise, if you cause injury to the central government, it will be nation. And if you cause injury to the state government, it will not be a nation. That is, sorry. Coming to what you are asking about judicial restraint, I have already pointed out, and one more thing which I will say we have used in the Act, it is because of our constitutional history, because our constitutional history is that we were required to be loyal, and that is why the question of disaffection was or affection was there under the Act. Now, as I am saying, that Kedarnath Singh case today reads down section 124, so we can't really read section 124 IPC as it exists today without taking into account Kedarnath Singh's case. So if an act or omission, a writing, falls within the ambit of the proposition of Kedarnath Singh case, it is a sedition. If it does not fall, it is not a sedition. That is one fundamental point. And there you will find that the word disaffection has not appeared. So what we require today is no violence, and secondly, no causing of public disorder. Now, whether we should have a law or not, I'm not on the terminology used. You may use a different terminology. But as Madam Anu has said and others, do we not need a law? Even Mr. Tiku has said, because if somebody tries to incite violence, if somebody tries to create public disorder, do we need a law in this country or do we not need the law? If we don't need the law, matter ends there. But if we need the law in order to maintain discipline and public order, then in that event the law is necessary, whether we name it as sedition or we don't give any name to this act or omission and define it as a offense. Now, coming as far as your question of judicial restraint is concerned, I have already mentioned that the court is required to apply judicial restraint because any observation made may destroy a person today. And tomorrow what happens? I have already given an example of Kanhaiya Singh's case where he has been described as a gangrene for the society. How do we know tomorrow he is going to be convicted? If he is acquitted, what will happen to the observation which has been made? Because we have seen on the TV, every time a debate appears that bail order is produced, and the anger also does not know. The person is speaking for the political party. He also does not know that a bail order is only an interim order. It will eventually merge with the conviction or acquittal of a person. So that is a temporary kind of a thing. And depending on that, no, he has been described by the court itself as gangrene. This is something which courts have to be really wise.
Correct, sir. So thank you so much for the insightful answer, sir. Ma'am, coming to you, Geeta, ma'am. Am I audible to you, ma'am? Geeta, ma'am?
Yes, you are audible.
Right, ma'am. Ma'am, India is a signatory to various conventions and treaties, including International Convention on Civil and Political Rights, ICCPR, in 1979. It sets forth international standards for protection of freedom and expression in world, ma'am. Ma'am, are we not violating such provisions with the prevalent of such statutes, ma'am?
So
statute as that of sedition?
The statute is something which I would prefer not to be on the statute book. And the Law Commission has also recommended its repeal, if not the repeal, for toning it down so that the language does not do disservice to the right freedom of speech. And Anu, of course, in her usual research, pointed out how the two need to be balanced. And none of us, particularly where we see a lot of irresponsible writing and reporting, would be unconscious of the fact that you do need a balance between right to freedom of speech and expression and making seditious statements. But the question is, the cases that are being filed in the name of sedition are, are, are a gross misuse of the law of sedition. And for that, one of the only answers is that there should be, even government and the state should be paying damages if a person is acquitted after a false criminal prosecution.
Ma'am,
That's the answer.
ma'am, that brings me to a question to
And this is without saying that, according to me, sedition, either the law should be amended or it should be abrogated. But without saying that, it's the misuse which bothers me more.
Absolutely, ma'am. Ma'am, coming up, thank you so much, ma'am. Manan sir, coming over to you, sir. So, section 124A, which is a charging section for sedition, according to me, is an analogy of sedition of section 66A of IT, sir, IT Act, which the Honorable Supreme Court in Shia single case has repealed. This in itself, this shows that the law in itself wasn't bad, but its implementation was, sir. So what's your take on it, sir?
You see that, as I said, that far and against arguments is also there that this is a vague law, inconsistent with international commitments, unnecessary provision. Because there are other provisions in the Indian Penal Code and UAPA Act, that is 1967, that criminalize disrupting the public order or overthrowing the government, the violence and illegal means. One example is section 121A, which penalizes the conspiracy to wage war against the government. Therefore, as there are other provisions which criminalize actually tangible threats to the government, section 124A is not required. The question is that we have other acts in which the person can be actually booked, can be tried, but as every panelist and Justice Iqbal Ansari has elaborated, Mr. Tiku and Mr. Pavan, even Geeta ji also elaborated each and everything. So my view is that again I will come on the same point, that limitation. For everybody there is a Lakshman Rekha, as Justice Iqbal Ansari ji has elaborated regarding the state. State means that the India means that whether any state means Haryana, Punjab, every state comes under central union government of India. So I will say only one thing, that number of other sections are in the IPC. Other laws are there which are not required. Similar sections, similar punishment, and similar ingredient of these sections are there, but still the sections are there.
Sorry, it was muted. Sir, absolutely grateful for your such lovely answers, sir. In fact, you're sailing in the same boat. Prior to this, 5 minutes before, I said the same thing, sir. And thank you, sir, so much for confirming the same, sir. That various other provisions, right from 121 to 124A, then UAPA and other provisions are there. So why have multiplicity of cases and a poor and a person languishing in jail for years and years, later on he gets acquitted, sir, I doubt that would that acquittal really affect to him, sir? So coming to one more little more question, sir. This act requires, sir, a lawyer with specialization in the field, sir. And such lawyers, may I point it out directly, sir, lawyers like you are not easy to afford, sir. I mean, we understand the fees which are charged, sir, and that is beyond a normal person's scope to engage lawyers like you. Of course, magnanimity is there that you do pro bono cases, but how many pro bono cases can you do, sir? Ultimately, that is also one of the questions, sir. So, does it not end in a denial of a justice that if an accused cannot, which is a constitutional right, sir, to have a lawyer of his choice, is not being able to afford it, sir? What's your take on this, sir?
You see that pro bono case. I can give an example of top lawyer of the country and one of the best lawyer of the world, Harish Salvi. He does pro bono cases. But in pro bono, he is being compensated with his publicity. He did cases of Arnav Goswami pro bono. But he got the publicity to that extent that the number of big industrialists in the country engaged him. So pro bono means that the persons who are not able to pay the fee are unable to engage a good lawyer, having good case, but not able to convey his case to the judge. For that purpose, every court has panel lawyers, that mediation, etc. And in every
so
court, so far as me is concerned, so whereas others are concerned, I do also pro bono cases where I can give an example. You see, overnight I have not become this KK Manan. I started from Patiala House Court. I did my juniorship 4 years with the top lawyer of Patiala, Baldev Mehta. But thereafter, when I became independent, I started charging fees at that time 200, 300, 500. Even today, those clients from, I will not name the areas of that rural areas, people comes, I'm standing instructions to my clerk is there that whatever they will pay, you accept it. Don't quote your own fees, because they are my clients when I was a lawyer of beginning. Like me, other lawyers are also having the same habit, same system, no doubt in it. Tomorrow, day is not far away when you will become, because every सास, हर सास कभी बहू होती है, हम भी कभी बहू
grateful for your blessing, sir.
So I assisted Geeta Luthra's father in number of cases, and time had come, then we appeared against each other also. So likewise, I appeared, I briefed Ram Jethmalani even in Asaram case also. But I did against, we did against each other also, and Amit Shah, and I had gone for his co-accused persons. Amit Shah was being represented by Jethmalani. KTS Tulsi, he was for the CBI. So KTS Tulsi ji also came from Punjab, and he was not a very big lawyer at that time as he is today. So like that, even Jethmalani ji also started from district court in Bombay. He is used to do custom cases there. So pro bono, I can say in one word, you can send any number of cases if really they require. If they can afford the fees, they must. If they can't, then I can assure you on behalf of Geeta, behalf of Pawan, or even who are listening me, and even Tiku, है तो कंजूस है बड़ा, अब क्या करूँ इसके बारे में, मेरा तो उस पे but anyway, even Ansari ji is also can afford it in the Supreme Court. So every lawyer, one thing more which I'm in the audience,
Sir,
Divyansh is a son of also a judge. And I just recently attended his marriage in Jaipur and belonged to a very good family. His dada, now expired recently, was a great prosecutor, chief prosecutor in Pisajari. I learnt a lot from him. His soberness, his magnanimity, to the extent I can say, what a sharafat in the man. And his now uncle, Sanjay Rathi, is in the Bar Council with me. So now this boy, I will say best of luck. Like, I mean, see, these
Sir,
people have to rise. They are rising star in the bar. They will ultimately rule the bar. You will see, time will come, they will rule the bar. I started, and Tiku ji also started. Pavan ji was with my another great friend. He was working with him, Harish Gulati ji, and he knows it, how we fight in the court. So, pro bono word is a sophisticated word. हमारे तो ट्रायल कोर्ट में कहते हैं चल यार फ्री द वकील कर लो, फ्री द वकील कर लो. फ्री द वकील द मतलब does not mean that that lawyer is easily available. But I remember Justice Indermeet Kaur Kochar, she was judge in charge in Patiala House. She called me and Ramesh Gupta ji. She said that we both should do free of cost at least 2 or 3 cases every month. We accepted that. She said, we know that you don't have time, but I'm requesting other judges also, colleagues, they should give you the cases. So we did it. No doubt in it.
So point well taken, sir. Now next time when Divyansh has a matter, sir, or I have a matter, we take it as a matter of right, which I have always taken it, sir, to engage you, sir, without paying any, with paying a token fee of 1 rupee, sir. That I understand, sir.
You see,
the
Divyansh,
moot point was, sir.
Listen. You see, I may be pardoned to waste the precious time of the audience as well as of the panelists. Divyansh, Dada, grandfather, he did not practice after his retirement. He has gone to the village nearby Delhi. He used to help free of cost, not only of his village, but other villages. Lot of people used to come and take his help, and he did it.
Absolutely, sir.
And he did
it.
Absolutely,
sir. So Divyansh, now as a matter of right, please engage sir with a token fee of 1 rupee, and let's have some sedition cases.
Uncle Sanjay is also very intelligent.
Sir, I agree to that. The moot point was of normal lawyers.
I'll just take.
Sir, Pavan Bhaiya, I'll just come back to you. Just let me ask one question from Geeta ma'am.
I'm supplementing. I'm supplementing what Mr. Manan has said. What is happening is we are not invoking Article 22(1) because every accused has a right to engage a lawyer of his own choice. And it is the duty of the state to pay the fee of that lawyer. And I know some of the cases where topmost criminal lawyers were engaged by the accused and their fee was paid by the state. Mr. Manan would be knowing about it. So it is not a thing that people who can't afford can't get a good legal help. If you invoke those rights which are available with you, you can easily take services of any lawyer of your choice.
Absolutely, sir.
There have been orders of the trial court and even superior courts to pay their usual fee of that senior lawyer. And I know few of those cases.
Agreed.
This has been.
Agreed. Geeta ma'am, can I just revert back to you for a second? Ma'am, are you there?
Unmute karo apna.
Unmute sir, unmute.
Unmute nahi hai Geeta ji.
Geeta ma'am, are you there, ma'am?
I think so. She's not there, sir.
Maybe the connection got connected. Pavan Bhaiya, I'll put this question to you. In case of a democracy, what would be the difference between sedition and dissent? in the light of Vinod Dua's case recently?
Vinod Dua's case, if you read the entire judgment, I just want to make one comment. What the Honorable Supreme Court has done has reiterated Kedarnath case. Other than that, what they have said that the Kedarnath principle should be applied and journalists should not be arrested in the cases of sedition. And yes, one thing they have done, they have quashed the FIR, thereby meaning what Vinod Dua said does not come within the definition of sedition as set in Kedarnath's case. But what you are asking is something different. Dissent and sedition are clearly covered. I have said again, I'll say it again, by Ram Manohar Lohia and Shreya Singhal. Those two paragraphs, short paragraphs, they clearly define or tell you a difference between what is dissent and what is sedition. Unless an incitement takes place from something said by me, it does not come within the definition of sedition. There has to be an act much more than what is required. And even 124A also in explanation covers up those things. It says there has to be an incitement. Merely saying something which may not lead to any violence or incitement or disaffection is not covered under sedition. Period. And otherwise, dissent is heart of our democracy. Constitution provides us that right. To an extent, only 19.2 says, I'll tell you, there is another thing, what Justice Ansari also said. When the Select Committee headed by Sardar Patel drafted section Article 13, their word sedition was used. It was given away. But First Amendment never brought in sedition as under 19.2. What was brought in was public order. And other words were brought in. So what we have to see is whether what a person says under his right of freedom of speech impacts public order, and by impacting that public order, incitement is caused. Similarly, you will see 295A, 153, 150. So all those sections require something more. So that is the difference.
Correct. Coming on to Anu, could you please sum up today's show in just in a limited time period, please?
Yes, Manan sir. Yes, sir. Manan sir wants to say something.
Yeah. How much time you will take?
Sir, please, sir. Please share your thoughts.
No. How much time people will take now more?
Robbie, can we all leave, please?
Ma'am, we are ending up, ma'am.
I
have a meeting.
Ma'am, you were missing. Ma'am, you were missing. On a question, you were missing, ma'am. We were all looking up for your answer.
I am so sorry. My mistake. I was just walking for a minute, or maybe went to the restroom. That may have been. But
he always does 3-4 works at a time.
Rubinder sir, we can probably finish it now. And
Anu, please, can you finish
I'll just
the show?
conclude. Yeah. Robbie, I'll just conclude. I'll just have to say 2 lines. The purpose and intent of 124A, from the very fact that it falls in Chapter 6 and relates to national security, and starting with 121, it is in the category, almost in the same category, is to ensure that there's public order, national integrity, safety, all those things are there. So by misusing of this provision, we belittle this provision. So we should ensure that for political persecution and for free thinkers on free speech, we don't put impingement by use or misuse of this provision and thereby dilute the provision. So in the present day and age, I will reiterate that this kind of scenario, geopolitical scenario, we do require a provision as strong as this, whereby the challenges of national security can be met with. But by diluting this provision, it is going to have a very detrimental effect. And therefore, we need to reform and we need to ensure that certain guidelines are there, how we follow in booking and use of the provision. But definitely we can't dispense with it. It's absolutely necessary.
Thank you so much.
Thank you.
Thank you. Thanks to all the panelists. Thank you, Justice Iqbal Ansari, sir. Thank you, KK Manan, sir. Thank you, Tiku, sir. Thank you, Pavan Bhaiya. Thank you, Anu. Thank you, Geeta, Luthra, ma'am. It's been a real pleasure to have you over. And stay safe. God bless. Thanks for the lovely. Thanks for joining the show.
Thank you so much.
Thanks to all the guests who have come. A heartfelt.
Thank you so much, everyone, for joining.
Thank you.
Thank you.
Thank you.
Thank you for, thank you all. Thank you, organizers.
Thank you, viewers, for joining today's session. It was indeed our pleasure, panelists, for sharing your views with us. Thank you so much.
Thank you.